exercise powers like this and say 370 is now otiose, or it stands repealed, or it stands withdrawn. Assembly will send a notification to the president or a resolution, and on that president alone can act. Justice, if not, it is now today contended by Government of India responsibly before this court that no, it has happened, but now governor can send in and we can act on it. But that will be not virtually not destroying this very express provision. Then they go forward and say in Article B, power of Parliament, in Article B2, Article, just a second, an Article, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President subject to this exercise of power under D, and read with the proviso, provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So, if it is part of instrument of accession, in consultation. If it is outside the instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be understood in the context of 356 and governor exercising omnipotent powers. That's why it is not very important for your lordships to read this in letter and spirit. So, the constitutional provisions are now added by 1C and 1D. Legislative powers are added by 371A, 1A and specifically B. The power of Parliament to make laws shall be limited. Please see the words. Shall be limited, mandatory, to those matters in Union list and the concurrent list which in consultation with Government of State are declared by President to correspond to matters specified in instrument of accession, governing accession of state to the dominion of India as matters with respect to which dominion legislature may make laws for that, and two, such other matters in the said list as with the concurrence of Government of State President may by order specify. Now, my lord, why is it temporary? Please see subarticle 2. Please see subarticle 2. If concurrence of Government of State referred to in para 2 of subclause B, that is legislative power of clause 1, or in the second proviso to subclause D of that clause, that's constitutional provisions, be given before Constituent Assembly for the purpose of framing Constitution is convened, it shall be placed before such assembly for such decision as it may take thereon. Why? Because not democracy. You could only do it if Constituent Assembly approved it. It was a temporary provision. So the new Constituent Assembly is being now convened, and soon it may mean in the meanwhile, President may exercise powers in consultation with the state government under 1B or 1C or 1D. They said, yes, they can. But you place them before Constituent Assembly for a post facto approval. So, it was never intended to be permanent. It is a temporary provision. And the entire burden or entire onus or entire responsibility or entire power decision to make the applicability was left to the Constituent Assembly. This can't be wished away. This is a constitutional provision. President can't exercise powers like this and say 370 is now otiose, or it stands repealed, or it stands withdrawn. Now, in that context, please see Article 3, sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. So, my lord, he can either say it will be cease to be operative, or he can continue, or shall be operative, which means shall be continued, only with such exceptions and modifications, and from such date as he may specify. So, my lord, the power is both for President to continue or President to discontinue. If he wants to continue, we can continue in same fashion or with such exceptions and modification. But for President to do so, prior consent of the Constituent Assembly is a must, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues such a notification. So, Constituent Assembly will send a notification to the President or a resolution, and on that President alone can act. You can't rewrite this. It is not capable of any other understanding. It was therefore an exercise which was limited by in terms of the actions to be taken, not by efflux of time. But time becomes important because the life of Constituent Assembly was only till 1957. Now, Lord, Constituent Assembly, as your lordships have been told, Lord, went into it in Kashmir. They said, we want to be part of India. We want Constitution of India to apply to us. We want Article 370 to continue. President accepted that and issued CO in 1954. End of the matter. Where does he then have power to re-exercise that role? It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened, but now Governor can send in and we can act on it. Well, that will be virtually destroying this very express provision. And I respectfully submit that it is impossible to accede to that interpretation. It was a one-time exercise. It was not intended to be exercised again and again. Even Constituent Assembly was not given power to do it again and again. Supposing they passed a resolution later saying now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. So your lordships will have to look at it either way. That's why the word temporary is very meaningful as the heading of the article. So I respectfully submit that this article has lived its life, has achieved its purpose.